Well, I'm hoping that what I'm going to say is not going to be very technical and boring to all of you. But because there is so much debate as to, I mean, you hear these phrases like rarest of rare cases, etc. I just thought it important to take you through the journey from Bachchan Singh's case, which was the Constitution Bench judgment of the Supreme Court, to Yaqub Memon's case, so that you understand what actually constitutes rarest of rarest, whether there's any clarity on that issue at all. And so therefore I thought I will start with the legal landscape in which the question of the death penalty comes to be decided. Now, back in 1980, in a case called Bachchan Singh versus State of Punjab, the Constitution Bench of the Supreme Court, now the Constitution Bench of the Supreme Court is 5 judges or more, they were asked to determine whether it was constitutional to have the death penalty still in our statute books, and secondly, to give some kind of procedural guidelines for the application of the death penalty. Now, in Bachchan Singh's case, the constitutionality of the death penalty was, the 5-member bench held that it passed constitutional muster, but on substantive grounds, it made certain very, very important observations. Now, I'll just like to read from that so that you get a sense of what the Supreme Court said way back in 1980. On the issue of the requirement of the law, and I'll quote from paragraph 161 of the judgment, the Supreme Court said that a study of the propositions set out above will show that in substance the authority of none of them have affected by the legislative changes since the decision in Jagmohan's case. Of course, 2 of them require to be adjusted and attuned to the shift in the legislative policy. The first, and they were speaking in terms of the introduction of section 354(3), which mandates the court convicting a person for an offense punishable with death, or in the alternative with imprisonment for life or imprisonment for a term of years, to give special reasons to be recorded for such sentence. The expression special reasons in the context of this provision obviously means exceptional reasons founded on the exceptionally grave circumstances of the particular case relating to the crime as well as the criminal. Thus, the legislative policy now writ large and clear on the face of section 354(3) is that on conviction for murder and other capital offences punishable in the alternative with death under the penal code, the extreme penalty should be imposed only in extreme cases. Thereafter, in the very same judgment, the Supreme Court laid down that the sentencing discretion is to be exercised judicially on well-recognized principles after balancing all the aggravating and mitigating circumstances of the crime. By well-recognized principles, the court obviously meant the principles crystallized by judicial discretion, illustrating as to what was regarded as aggravating or mitigating circumstances in those cases. The legislative changes since Jagmohan, as we have already discussed, do not have the effect of abrogating or nullifying these principles. And then they went on to say that the 2 most paramount considerations were: 1, the extreme penalty can be inflicted only in gravest cases of extreme culpability, and 2, and this is very important, in making the choice of the sentence, in addition to the circumstances of the offense, due regard must be paid to the circumstances of the offender also. What the Supreme Court said in this landmark judgment, although it upheld the constitutional validity of the death penalty, was that while considering whether death penalty must be given in a particular case or not, the court, while sentencing, must take into account the aggravating and mitigating circumstances of the crime as well as the aggravating and mitigating circumstances of the criminal. And it ended this judgment in paragraph 209. It writes that, and this is very relevant even today, there are numerous other circumstances justifying the passing of the lighter sentence. We cannot obviously feed into a judicial computer all such situations, since they are astrological improbables in an imperfect and undulating society. Nonetheless, it cannot be overemphasized that the scope and concept of mitigating factors in the area of death penalty must receive a liberal and expansive consideration by the courts in accord with the sentencing policy writ large in section 354(3). Judges should never be bloodthirsty. Hanging of murderers has never been too good for them. Facts and figures, albeit incomplete, furnished by the Union of India show that in the past, courts have inflicted the extreme penalty with extreme infrequency, a fact which attests to the caution and compassion which they have always brought to bear on the exercise of their sentencing discretion in so grave a matter. It is therefore imperative to voice the concern that courts, aided by the broad illustrative guidelines indicated by us, will discharge the onerous function with ever more scrupulous care and humane concern directed along the high road of legislative policy outlined in section 354(3), namely that for persons convicted of murder, life imprisonment is the rule, death sentence an exception. A real and abiding concern for the dignity of human life postulates resistance to taking a life through law's instrumentality. That ought not to be done save in the rarest of rare cases when the alternative option of life is unquestionably foreclosed. Now, I've deliberately read out portions of Bachan Singh's judgment to say that, actually speaking, this is the law which operates in our country. It's a constitution bench judgment. It has never been overruled. This is the law which ought to have been followed. Even assuming, and I know Prashant has taken great pains in telling us why all of us here are, I think, opposed to the death penalty. But even assuming that, and it is a fact that death penalty continues to be in our statute, so that's the larger debate. My address today is aimed at looking at the Supreme Court judgments as they happened from 1980 onwards, to say that the Yaqub execution the Supreme Court did not even follow its own judgment. So the judgment which occupies constitutional space is the Bachan Singh judgment, where the Supreme Court said 2 or 3 very important things. One, that the death penalty must be given in the rarest of rare case, and that it must be given only when the option for life is unquestionably foreclosed. It also went on to say that it is not just the circumstances of the crime, the aggravating and the mitigating circumstances of the crime which is relevant. The circumstances of the criminal, the aggravating and mitigating circumstances of the criminal is equally relevant while sentencing a man to death. Now, this was Bachan Singh way back in 1980, 5-member bench still holding constitutional ground. But in 1983, a 3-member bench of the Supreme Court in Machi Singh versus State, while paying lip service to the Bachan Singh injunction, introduced an inconsistency that now lies at the heart of the death penalty determinations by courts. Now, in para 33 of Machi Singh's judgment, the Supreme Court, now this is a 3-member bench, only a bench of a higher constitution, 7 or more, could have overruled Bachan Singh, but a 3-member bench decided to carve out 5 categories of cases in which the community's conscience was so shocked that it will expect the holders of the Judicial Power Center to inflict the death penalty. This community's conscience, or the collective conscience of the community, did not suddenly happen in Afzal Guru's case. This has been a language that the Supreme Court has used way back in 1983. Now, Bachan Singh had specifically refused to list out categories of cases which would fall within the rarest of rare ambit. But instead, in Machi Singh's case in 1983, the Supreme Court emphasized on only the circumstances of the crime and not the circumstances of the criminal. So this was a departure from the Constitution Bench judgment of the Supreme Court, and many such judgments happened. In fact, if I was to quote a particular portion of Machi Singh's judgment, one of the aggravating factors they mention is, before opting for death penalty, the circumstances of the offender also requires to be taken into consideration along with the circumstances of the crime. Now, so it did pay lip service to Bachchan Singh's case, but there was a serious departure. The next few years, we saw that departure happening in a greater way, and we finally have a judgment of the Supreme Court in 1996 called Ravji versus State of Rajasthan, where we went through a period of further confusion, further judicial confusion in the application of the rarest of rare formula, leading us to this judgment where the Supreme Court almost, a two-member bench, almost arbitrarily overruled the Bachchan Singh verdict. And in para 24 of the judgment, it is shocking, but this is what the Supreme Court said. It is the nature and gravity of the crime, but not the criminal, which are germane for consideration of appropriate punishment in a criminal trial. So can you see the shift? Bachchan Singh in 1980 Constitution Bench judgment talked of circumstances of the crime as well as the circumstances of the criminal, and if there were mitigating factors which go towards establishing that the criminal required mercy, that had to be taken into account. But in 1996, a two-member bench said it was only the nature and gravity of the crime, but not the criminal, which were germane for the consideration of appropriate punishment in a criminal trial. This went on for some time, and finally, in order to bring some order to this chaos, the Supreme Court in a judgment decided on May 13, 2009 called Santosh Kumar Bariyar versus State of Maharashtra, attempted to derive further guidelines from Bachchan Singh on how capital sentencing ought to be conducted, and once again focused on circumstances of the crime as well as the criminal, and the alternative punishment of life was once again, the idea was once again highlighted. It was the court focused on the requirement that the alternative punishment of life had to be unquestionably foreclosed before you could invoke the death penalty. Now, what was interesting in this judgment, and the reason why I am reading it, is that in 2 or 3 paragraphs of this judgment, the Supreme Court, in fact, has expressed horror that Bachchan Singh's guidelines were not followed. And it says that curiously in Ravji versus State of Rajasthan, this court held that it is only circumstances relating to the crime to the exclusion of the ones relating to the criminal which are relevant to sentencing in a criminal trial. We are not oblivious that Ravji's case has been followed in at least 6 decisions of the court in which death penalty has been awarded in the last 9 years. Look at the horror of this. A wrong or deliberate interpretation of a Constitution Bench judgment of the Supreme Court results in 6 wrong executions, and this has been highlighted in Santosh Kumar Bariyar's case, where they're saying we are not oblivious that Ravji's case has been followed in at least 6 decisions of this court in which death penalty has been awarded in the last 9 years, but in our opinion, it was rendered per incuriam. So therefore, and then the Supreme Court has quoted those 6 decisions. In this case of Santosh Kumar Bariyar, once again, the Supreme Court tried to regain the moral high ground by saying that as far as death penalty is concerned, we must look into both the circumstances of the crime as well as the circumstances of the criminal. Now, in the Delhi High Court, in several judgments, this formula has been taken into account. For the last 1 or 2 years, there's been a bench which has been set up specially to look into death penalty matters, a bench headed by Justice Muralidhar and Justice Mukta Gupta, in which, at the time of sentencing, the court has called for reports. They've had evidentiary hearings, and they have called for reports from the jail superintendent to find out what the conduct of the prisoner in jail was. They have called for reports from the probation officers to answer the question, is there a probability that the accused can be reformed and rehabilitated? Because at the center of the sentencing policy is reform and rehabilitation. And that attempt was made by the Delhi High Court in several of its judgments, and they reached the conclusion in these cases after reading the probation officer's report and the jail superintendent's report, that in fact the criminal could be rehabilitated, and therefore they commuted the death sentence to life imprisonment. This was a special evidentiary hearing held at the time of sentencing. Now, what actually happened, I've just very quickly gone through the judgments from 1980 to now. Now, in Yaqub's case, at the time when the appeal was first heard, to my understanding, about 3.5 paragraphs were devoted to sentencing. And what the Supreme Court said in para 873 was that the two cardinal principles, namely penalty imposed must be proportionate to the gravity of the crime, and second, the degree of responsibility of the offender must be taken into account in determining the sentence for an individual accused, in addition to aggravating and mitigating circumstances. Really lip service to what Bachchan Singh asked them to do. And after noting that as far as Yaqub Memon was concerned, the main evidence against him was confessional statements of co-accused persons under TADA, which was subsequently retracted. I must once again repeat that TADA, as it operated during the pendency of this case, has been repealed today. Today, under general law and under its successor law, the Unlawful Activities Act, the confessional statement of a co-accused cannot be used against an accused. But at that time, when Yaqub was charged and was prosecuted and ultimately convicted and sentenced, TADA was in operation, and by virtue of that fact, the confessional statements of co-accused persons was taken as evidence against him. And the Supreme Court concedes that other than these confessional statements, his role really was very peripheral. And yet it did not follow the judgment of its own court laid down in Bachchan Singh's case. It did not go through the process of itemizing the mitigating and aggravating circumstances of the crime as well as the criminal. And had it done so, I would imagine the result would have been very different. Now, in the mercy petition which Yaqub Memon filed before the president a day before he died, he has actually itemized these circumstances. And I will quote from there. He's writing an article written by B. Raman, who as head of the Pakistan Desk Counter-Terrorism Division of the Research and Analysis Wing, published posthumously on July 24, 2015, has disclosed some shocking facts pertaining to my case. Raman laments that the cooperation of Yaqub and the investigating agencies after he was picked up informally in Kathmandu, and his role in persuading some other members of his family to come to Pakistan and surrender, constitute a strong mitigating circumstance which seems to have been hidden by the prosecution in their urge to secure a death penalty. He further goes on to say that, and this is really how the state plays games with you, the TADA court had issued the death warrant in his case on 30th of April 2015. Under the law, he was supposed to have been communicated that decision forthwith. He was told of that only on 14th of July 2015. That is 2.5 months after the death warrant had been issued, thereby giving him about 15 days before the scheduled date of execution to pursue his various legal remedies, which clearly was in violation with many judgments of the Supreme Court, including the judgment of Shatrughan Chauhan. He had also detailed that he was mentally unfit for an execution. And I quote, "I submit before your excellency that I have been suffering from schizophrenia for the last 20 years, which makes me unfit for execution. Jail doctors have certified my deteriorating mental condition. Schizophrenia as a mental condition has been recognized by the Supreme Court to be a medical illness which renders a convict unfit for execution." And then he's quoted Shatrughan Chauhan's judgment of the Supreme Court. But what was very interesting, and I will like to end with that, is how he formulated the argument that death sentence of convicts in other terror cases were being commuted, whereas his was not being commuted. And this is what he writes: "It is also worthwhile to note that death sentences imposed on the aides of Veerappan, convicted and sentenced to death under TADA, Rajiv Gandhi killers, Devinder Pal Singh Bhullar, have been commuted recently by the Honorable Supreme Court. while the mercy petitions of Veerappan's aide, Rajiv Gandhi's three killers, and Devinder Pal Singh Bhullar were decided belatedly, thereby giving them the claim of delayed jurisprudence, the Home Ministry have moved swiftly to reject my mercy petition. Likewise, the mercy petition filed by Balwant Singh Rajana, the prime accused convicted for the assassination of Beyant Singh, former Chief Minister of Punjab, also has been kept pending by the Home Ministry. It seems that the law and its bureaucracy favor a class of people over the other. Secret hangings of Afzal Guru and Ajmal Kasab, and now my impending execution begs the conclusion that the heavy hand of punishment and legal mercy is somehow reserved for Muslims in this country. The reason I read out this last mercy plea of Yaqub himself, because it gave rise to that midnight hearing, and I know both Usha and Professor Surendra Nath will talk about it. But you know, it was being celebrated by the media as though something very great had happened. It was a victory for democracy that at 3 a.m. in the morning we woke up the Attorney General and 3 judges of the Supreme Court. Well, I don't think so, because it was the job of the Supreme Court to protect the life of an individual who was claiming that protection on the basis of the law laid down by the Supreme Court. I'm not going into the death penalty debate. I'm not saying let's consider whether death penalty is moral, whether it's linked with the idea of justice or not. That's a separate debate. What I'm saying is, even in those rarest of rare cases, which the Supreme Court itself has attempted to define, even there, the Supreme Court made it clear way back in 1980 that this was not the way to proceed with an execution. And it is that very Supreme Court which chose to ignore the Constitution Bench judgment of its own court and proceeded to execute Yaqub Memon, despite the fact that there were several mitigating circumstances which would have allowed the state to commute his sentence from death to life. And it failed to do so. So if someone woke up at 3 a.m. in the morning, I am not feeling particularly grateful for that exercise, because as citizens of a liberal democracy, we expect our institutions to be awake 24 hours a day to protect us from these kind of aberrations. And therefore, that was not something that required celebration. What we should have seen was that after waking up at 3 in the morning, did the Supreme Court follow its own law? And it is my respectful submission that they did not. And in not following their own law, they committed a grave miscarriage of justice, which could easily have been avoided. Thank you.